This conference will now be recorded.
All right. Good afternoon, everybody. Welcome to our presentation on Arizona supported decision making for people with disabilities and their supports. The Supported Decision Making Pilot Project is funded by the Arizona Developmental Disabilities Planning Council, and our project partners include the ARC of Arizona, Southwest Institute for Families and Children, and Arizona Center for Disability Law. Today's presenters are John Myers from the ARC of Arizona, myself, George Garcia from Southwest Institute for Families and Children, Sai In from Arizona Center for Disability Law, and Juliana Huerenya from Southwest Institute for Families and Children. And with that, I will now turn it over to Sai.
Hi, everyone, and thank you, George, for the introductions. I wanted to thank you all for attending the presentation today and taking time out of your busy day to be with us so that we can share with you what we've been working on for the past few years. So, as George said, my name is Sai In. I'm a staff attorney with the Arizona Center for Disability Law. And I am going to kick things off with a discussion on guardianship because although our primary focus is supported decision making, it's really important to understand supported decision making in the context of what guardianship is. So what is guardianship? To start off this section of the presentation, if you all could answer the following poll question: how familiar are you with guardianship? Type 1 for I do not know anything about guardianship. Type 2 for I have some knowledge of guardianship. And type 3 for I am very familiar with guardianship. And feel free to put your answers in the chat box. So it looks like it looks like 2s across the board so far, which is good. So that means you all have some framework, some knowledge of what guardianship is. And then I'm hoping that with this presentation, with my section of the presentation, you'll get some more information about what guardianship, or you'll get some more information about what guardianship is. So what is guardianship? In this section, I'm going to talk about some legal definitions. I'm going to talk about individual rights, testamentary and guardianship by petition, who can be appointed a guardian, and steps an individual takes to be a guardian of another individual. So a guardian is it's a process, it's a legal process, and it's where an individual is appointed by court order to care for another individual determined to be incapacitated. So what does incapacitated mean? Well, the Arizona Revised Statute or Arizona law defines incapacitated as someone who is impaired by reason of mental illness, deficiency, disorder, physical illness, physical disability, chronic drug use, or it can be someone who lacks sufficient understanding or capacity to make or communicate responsible decisions. So what that last part means is that the individual who is subject to guardianship might not have sufficient understanding or enough understanding to make or communicate decisions concerning their well-being. So what's at stake? A lot's at stake, and I'm going to cover this a little bit more, but with guardianship, the court is essentially vesting decision-making, taking away decision-making from one individual and giving it to another. And here are some of the duties that are prescribed to the guardian, or duties of the guardian. And again, this is found in Arizona law, and some of the duties include the general health care of the individual, training and education if it's appropriate, like vocational training, training at a community college perhaps, clothing, furniture, vehicles, and other personal effects. So managing all of that. Receiving money if the individual is entitled to it, unless the individual has a conservator in place. And finding the least restrictive setting for the individual. So finding an appropriate setting that will care for the individual, but making sure it's the least restrictive possible. So here are a couple of rights that are at stake. So this is not a comprehensive or full list, but some rights that are at stake include the right to vote, the right to make healthcare decisions, the right to find education or pursue education or training, consenting to marriage, and making financial decisions. So the last one is pretty broad, and it can include anything from making small purchases, like things you would find like at a store, like a Target or a Walmart, to larger financial decisions. So who can be appointed a guardian? Generally, any person who will act in the individual's best interest. But again, this section is dictated by Arizona law, and the statute has a sort of hierarchy. The judge presiding over the case does not necessarily have to follow this hierarchy, but it's sort of a guide. And the hierarchy starts off with someone who's already appointed a guardian of another individual in the same county this individual currently lives in. Someone who is nominated by the individual who's subject to guardianship. A person nominated by the individual's power of attorney. A spouse, adult child of the individual. And those two generally come into play with older adults who have age-related disabilities and might need a guardian. And any other relative of the individual who the individual has lived with for the past 6 months. There are other individuals who can be considered, but here, this is just a kind of like a short list of the individuals who are prioritized. So there are a couple of different ways or paths to becoming a guardian. So one is through testamentary means, and I'm not going to go over it too much, but this is usually done through a will or other similar writing, and it's generally done in the context of a parent or a spouse who has guardianship of their adult child or spouse, and they just want to make sure that there is an appropriate guardian to care for their loved ones should they become incapacitated. And again, it's usually done by will or other similar writings, and it goes through similar processes as the guardianship that we all know of, guardianship by petition. So in this case, an interested party, so the guardian or the person who wants to be the guardian will petition the court, and that is the court in the county the individual subject to guardianship lives. and they will petition the court to become the guardian of the individual. So there are due process rights for the person who is subject to guardianship. Those due process rights include being represented by an attorney, and if the individual cannot afford an attorney, the court will assign an attorney to the individual. The individual has the right to put forth their own evidence, and evidence can come in the form of their own medical evaluation from their doctor or other healthcare provider, put forth their own testimony, gather evidence from other people, other testimony from other people. And the individual has the right to receive notice, which means there has to be enough time for the individual to get a notice that there are guardianship proceedings that are being presented so that they can prepare for the guardianship proceedings appropriately. There's also, the court will also appoint an investigator, and the investigator will interview all the interested parties, including the individual subject to guardianship and the prospective guardian. And that investigator will prepare a report and will make the report available to the judge or the court. And after all of this, the judge will review all of the evidence that has been presented and will determine whether guardianship is appropriate. The last part of this slide talks about court-appointed fiduciaries. So there are two types of fiduciaries. There are public and private fiduciaries. Private fiduciaries are paid. They're corporations who act as fiduciaries or guardians for these individuals. And you usually get this in the context of adult children who want to be guardians of their parents. So say there's a parent who has an age-related disability like dementia, and there are that parent has 2 or 3 children who all want to be guardians. As a good compromise, those parties can all agree to a private fiduciary managing mom or dad's affairs. Then there are public fiduciaries. Public fiduciaries are guardians of last resort. So if there is no individual who is willing or able to care for and be guardian of another individual, then the court will hire, or not hire, but appoint a public fiduciary to assume those roles. So this brings us to our first questions section. So if you have any questions about what I just spoke about, feel free to type it into the chat box, or feel free to unmute yourself. And if you don't have any questions right now, feel free to drop a question at any time during the presentation. So not seeing any questions, I'm going to go on to the next section. So rights of a person under guardianship. And I'm going to start off with this quote from former Senator Claude Pepper. The quote reads, "The typical ward has fewer rights than the typical convicted felon. By appointing a guardian, the court entrusts to someone else the power to choose where they will live, what medical treatment they will get, and in rare cases, when they will die. It is, in one short sentence, the most punitive civil penalty that can be levied against an American citizen." So that's a pretty powerful quote. And I want to unpack it a little bit. So the reason why I introduced this quote is because it really underscores how big of a deal guardianship is, and the types of considerations individuals should take when considering guardianship. So we start off this section with this powerful quote to kind of lay it all out there. And I'm getting a note from GoToMeeting that says the connection with GoToMeeting server has been lost. So if you, if at any time you can't hear what I'm saying, just, and if you can, just type it into the chat box. So rights of a person under guardianship. So so under full guardianship, all rights are taken away. And under limited guardianship, it depends on what the court order is and what the individual who's petitioning for guardianship is seeking. So here's a little bit more about limited guardianship and a little bit more in the context of voting, because voting is often the right that is most petitioned for to retain. So, or to be retained, my apologies. So what does the law say? Person for whom a limited guardian is appointed shall retain the right to vote if the person files a petition, has a hearing, and the judge determines by clear and convincing evidence that the person retains sufficient understanding to exercise the right to vote. So again, I talked about it a little bit earlier, but if an individual is seeking limited guardianship or guardianship, that individual would need to go to the courthouse in the same county as the individual who is subject to guardianship and then file the petition that way. Here's some more information about limited guardianship in the context of voting. So if an individual wants to retain the right to vote, the judge would want to make sure that the individual understands the processes that are associated with voting and would want to make sure what their interests are in politics. And these are like, these are just like vague, these aren't very specific statements. The judge isn't going to ask like who, or the judge may ask, but unlikely that the judge will ask really, really specific questions. The judge just wants to understand whether the individual understands what the right to vote means. And a quick note, if an individual is under full guardianship right now, that individual can petition the court to have the right to vote be restored. And restoration of rights is can be a difficult process. And if a family or a guardian is seeking restoration of rights, then I highly recommend that the family or guardian seek counsel when going through these processes. So other rights under limited guardianship. So the prospective guardian can ask the court to grant guardianship in specific areas. And these can include, and this isn't a full list, but here are some things that the prospective guardian can ask for in limited guardianship. Consenting to medical treatment, arranging education or training, applying for public assistance, consenting to outpatient mental health care, consenting to making living arrangements, and consenting to marriage. So in this case, it's really important to determine what areas the individual needs help with, or what areas the individual lacks capacity in. So instead of going the full guardianship route, the individual who is applying to be guardian can see what areas the individual needs help with and look to get limited guardianship in just those specific areas. And I'm going to end this section with a final quote, and this quote is from the Superior Court of Arizona. The quote reads, "Guardianship is a serious business. A ward cannot vote or marry, get a driver's license, buy property, use a credit card, or take out a loan." So again, it's very similar to that first quote from Senator Claude Pepper. It just really underscores how big of a deal guardianship is. And in the context of this presentation, it underscores the need to review other alternatives before going the guardianship route. So I'm going to pause again for another questions and answers if anyone has any questions. So again, if you have a question, feel free to type it in the chat box. And if you don't have a question right now, feel free, but you do have a question later on, feel free to ask us at any time. So not seeing any questions, I'm going to turn it over to the next presenter, Mr. John Myers.
Thank you very much, Cy. Good afternoon, everyone. Thank you for joining us this afternoon for this presentation on supported decision-making. Cy has given us an overview of guardianship and what is involved with guardianship and what it entails. So I'm going to dive right into what supported decision-making is in contrast to guardianship. Before I do that, though, I want to take another poll. If you would, in the chat box, please answer the following question. How familiar are you with supported decision-making, or SDM? 1, I don't know anything about supported decision-making. 2, I have some knowledge of it. Or 3, I am very familiar with supported decision-making. If you could just type your answer into the chat box, that would be great. Okay, we're getting a variety of answers to that question. We've got some 1s, we've got a 3, we've got some 2s. So it looks like there's some diversity in the amount that people know. Another 3 just came in. So there's some diversity in the amount that people know about supported decision-making as a concept and as an alternative to guardianship. That's great. We hope even if you are well informed about it, we hope that you'll learn something from today's presentation. And if you don't know much, then we hope you'll leave here feeling as though you've gained quite a bit of knowledge.
Hey, John.
Before we start, also, I want to share a story of a young woman named Gabby Castro. Gabby has spina bifida. She lives in Massachusetts and decided that she wanted to try supported decision-making as a structure in her life. Now, Gabby also has some associated medical issues that go along with her spina bifida. One of those is some severe vision loss. Her doctor told her that there was a possibility to help correct that if she had eye surgery. But surgery is a big deal. Surgery can be a major decision in life, and Gabby didn't want to make that decision on her own. So she pulled together her supported decision-making team, her supporters, and asked them to help guide her in making the decision. Ultimately, they gave her advice, and she made the decision that she did want to go through with the eye surgery, which proved to be very successful for her. And she said afterward, I could show the doctors who I really was, that I could speak up for myself. To have people look at me the way I want them to look at me feels great, because Gabby was the decision maker for herself. She just relied upon input from others to help her understand the implications of the decision she was going to make. Now, we all know that life is all about choices. It's about decisions. And every day we have to make dozens or maybe even hundreds of decisions, both big and small. We have to decide what to wear, what we're going to eat, what we need to do in a given day. And sometimes we aren't sure which choice to make. Sometimes we need help to make important decisions. So we ask other people in our lives, parents or friends or teachers or coworkers and so on, to help us make certain choices or decisions. For example, have you ever wondered whether you should spend the money to go see a movie that just came out at your local theater? It might sound exciting, you might really want to see it, but you also want to make certain it's really as good as the advertising says it is. So maybe you ask a friend who has already seen that movie for her opinion, or maybe you read a review of the movie on a website. Well, these are examples of supported decision-making, asking for help or input from other people to help you make a choice. Other examples of supported decision making might include the things you see on the screen here. What you should wear to a party, what kind of food you should eat for dinner, whether or not you should buy a car, and if so, what kind of car you should buy, whether you should buy a house or maybe rent an apartment instead, what kind of job you should take on, where you should work, and so on and so forth. The list goes on. Now, you're always free to accept the input or the advice that you get from other people. You're free to accept it or reject it, or to seek multiple sources of input. But the final decision is always yours. And people with different disabilities are no different from anybody else. They face the same decisions and life choices that everybody else faces, and they deserve the opportunity to make decisions about these things to the extent they're capable of doing so. For some people with disabilities, making decisions on their own can be more responsibility than they're comfortable handling. So in those cases, supported decision-making, the formal structure of supported decision-making, might be the right option for them. Supported decision-making can help people with disabilities keep their rights as adults while having the guidance and assistance they need from people they trust to ensure they're making well-informed decisions. Simply stated, it's a formal network of volunteer supports that's created to help a person with a disability make decisions and life choices. Now, people who choose to help the person with the disability make decisions are known as supporters, hence the name supported decision-making. Supporters are people who play an important role in the life of that person with the disability, and they might come from a wide variety of different backgrounds. In supported decision-making, these supporters sign an agreement promising to help the person with the disability in the various areas of life identified by that person with the disability. These agreements are known as supported decision-making agreements. Got ahead of myself. Although they sign an agreement, supporters are not paid. They're not given any form of compensation for providing their assistance. They help because they care about the person with the disability, because they want him or her to develop strong decision-making skills. Supporters might provide guidance or opinions or assistance or suggestions, whatever term you want to apply. But the decisions are not up to them. The person with the disability always has the power to make the final decision based on the information provided by the supporters. So what is supported decision-making? First, it's a way for people with disabilities to keep their personal rights rather than someone else being in charge of their lives. Second, it's a way for people who care about that person with a disability to voluntarily act as supporters who provide input and guidance regarding important decision-making in that person's life. And finally, and most important, supported decision-making is the process of people with disabilities making their own decisions with support and guidance from advisors they trust. It is not a system in which other people make decisions for a person with a disability. With supported decision-making in place, we as a society recognize that individuals with disabilities have the right to take risks and the right to choose the direction of their own lives. And I want to share with you another story. This is the story of Tucker Merle and his family. Tucker is a young man with cerebral palsy, and his mother, Jana, and father, Mark, got together with Tucker when he was about to turn 18, and they discussed whether they should appeal for guardianship for him because he has significant assistance needs. Well, they talked about it, and they decided that they were going to avoid guardianship for the time being, and they were going to give supported decision-making a try. And what they found was that it was enormously successful in their lives, and it was enormously affirming for Tucker to be the center of its supported decision-making structure. Jana said that Supported decision-making isn't just about not petitioning the court for guardianship. I quote her here, she said, "For us, it was all about using Tucker's existing network and explicitly talking about supported decision-making with them. It's no longer us making decisions for Tucker, now it's Tucker's decision. If he needs help, he asks for help from his team. They all understand that Tucker is a part of every conversation." And that's the foundation of supported decision-making. Quote again, "It's no longer us making decisions for Tucker, it's now Tucker's decision. He's part of every conversation." And I'll stop now to answer any questions you might have. If you do have any, please feel free to add them to the chat box, or feel free to unmute yourself and ask. I'm not seeing any come in, so I will go ahead and move on to the next section, which is making the decision about whether or not supported decision-making is right for you or for someone you love. And yet again, before we start, we want to ask a poll question. If you could answer in the chat box, how often do you, as an individual, ask other people to help you make decisions such as what to have for dinner or what movie to see, something like that? 1, you never ask other people for their input. 2, you sometimes do. 3, you do that often. Or 4, you always ask for somebody's opinion or somebody's input on decisions you're about to make. Okay, lots of 2s and 3s, lots of sometimes and often. That's great. That's great. There's nobody here who said they never ask for somebody else's opinion, and there's no one here so far who said they always ask for someone's opinion. Well, remember, supported decision-making is about receiving support, about receiving input and guidance and recommendations, but it's about receiving the right support at the right time to live as independently as possible. Really, it's what we all want from our lives. We all want to get the right kind of support from other people in our lives to help us live as independently as possible and make good, well-informed decisions. Supported decision-making rests on a basic belief that individuals with disabilities can make decisions about the various aspects of their lives. But I want to emphasize that, again, supported decision-making it's about receiving the right type of support and the proper amount of it to make choices for your own life so you can live independently. It is not, and I emphasize this, it is not the right choice for everyone. As Sai mentioned, we're not here to advocate for the end of guardianship. We're not here to say that guardianship is necessarily wrong. There is a role for guardianship because supported decision-making is not always the right decision or the right choice for a person. What works for some people, what might offer the authority that they've not had over their lives in the past, well, for others, it might require greater capacity than they possess. Or it might take a higher level of intervention from other people than is really practical. So in the end, supported decision-making requires that a person with a disability be able to communicate their wants and needs. They have to be able to make decisions for themselves and be able to share those decisions with others. Now, of course, no person with a disability is expected to know everything about all aspects of independent living. They're also not expected to make all the right decisions all the time. Life's really complex, no matter who you are. And all people, whether they live with a disability or not, have to deal with a variety of different issues and circumstances. And all people make mistakes. Every one of us makes mistakes. It's just a natural part of life. Supported decision-making can't eliminate those mistakes, although it is designed to help people with disabilities make the very best decisions as often as possible. One of its great merits is its ability to help people with disabilities learn from and grow from mistakes when they are made. So you have to start by asking yourself this question. Given the right support, can a person with a disability a particular person with a disability, make decisions for himself or herself? If you answered yes, supported decision-making might be the right choice. But there are several other key elements to deciding whether or not supported decision-making is the right choice for a particular individual. As mentioned, the first and most important thing to consider is the ability for the person with a disability to express their choices. It's vital that you discuss the capacity of this person to communicate their wants and needs. Second, if you decide supported decision-making is the right choice, it's important to talk about the kind of support the person with the disability is going to need. And third, you need to determine how much support the person's going to require and how often he or she will require it. Some people may be able to do certain things on their own very, very well, but they'll need support in other areas of life. For example, if a person chooses to live on their own, they may need support in finding an apartment or making sure they pay their rent on time every month. But making their meals and keeping their apartment clean might be something they can do very well on their own. Or if a person has medical appointments, they might need support in getting to those appointments on time, or they might need support making sure they understand what the doctor is telling them. But keeping up with their prescription medications is no problem for them at all. Also, if you decide to pursue supported decision-making as an option, you have to bear in mind that planning is key to successful supported decision-making. During your planning discussions, you need to consider many different topics, all of which can have an important impact on an individual's life. The list you see before you is by no means intended to be all-inclusive, but you certainly do need to consider things such as finances, what kinds of services an individual is receiving in his or her life, where that person's going to live, where that person's going to get medical care. Does that person work or does that person wish to work? What kind of education does that person have or does that person wish to receive? How does that person get around from one place to another? And again, the list goes on. And remember that planning may require the participation of a variety of different people who are involved in the life of that person with a disability. Not only family and friends, but perhaps teachers and other educators, perhaps faith leaders, employers or co-workers. Financial and legal advisors are very, very important. Healthcare professionals, certainly in the case of most people with disabilities, healthcare is a very important component of their lives. And this too is not intended to be an all-inclusive list. Bear in mind that no two people are going to have the same needs. So to help you think about the type of support the person with a disability will need, we suggest you try creating a list or a grid. Your list should include the part of life in which they'll need support and how they would like to receive that support. We've given you just a very simple demonstration of how you and your team might envision these needs. You can see on this chart, we've put two columns, area of support and how I would like to receive support, and we've thrown in some examples of finances, medical care, and employment. Ultimately, it's up to the person with a disability to decide what kind of support they'd like in their life and in which areas of life they want to receive support. But talking about the type of support a person will need should be an ongoing conversation. This, as I said, is just a simple demonstration of what a chart might look like, but it will probably include much, much more information than we have put into this sample. Talking about the type of support a person needs has to be an ongoing conversation because those needs are going to change over time. The person may need more support or less support as time passes. Now, you can use a chart just like this, and we've put a blank version of this in our curriculum materials that you can find at the Southwest Institute for Families and Children website under the Supported Decision-Making tab. You can use the chart we've provided or create one of your own, but we suggest that you use it to identify the areas of support where the person with a disability is going to need help, and that you write down how they'd like to receive that support. Feel free to add as many spaces as you need to make it work for your particular situation. In all likelihood, it's going to be much longer than what is on this page or what is on this screen. Bear in mind, as I said, the planning process is indispensable. And it's important that a variety of people be involved. But throughout the process, we can't say this often enough, throughout the process, everyone needs to remember that the individual with the disability is the ultimate decision maker. Supporters play an important, even vital role, but they are there only to provide support and not to make decisions for a person with a disability. Also bear in mind that supported decision making can only be truly effective if the individual has some capacity through either natural or assistive means to express their wishes and desires. Every person's life has many facets, and this variety needs to be considered in the course of the planning. An individual may need assistance in a wide range of areas or in a very narrow range of areas. Moreover, that assistance may be greater or lesser depending upon the area of life. So try to account for as many as possible as you go through this exercise. And finally, understand that planning is going to take time. It is not a 5 or 10-minute exercise. It will likely take hours, perhaps days, perhaps months to do full justice to it. But give it the time it deserves. Don't try to rush it, or you'll probably regret it later. If you invest wisely at the outset, it will definitely pay solid dividends throughout the course of the individual's life. And I'll pause again for any questions you may have about the nature of supported decision-making or making a decision about whether or not it's right for you. Hannah's asking, what if they have no natural supports? Can DDD support coordinators help with this? Yes, we certainly hope they can, and we certainly hope they will. They are the most obvious choice for those who don't have family or friends around them. A support coordinator should play a central role in this. Now, we also know that support coordinators carry heavy caseloads, most of them, and may not have all of the time necessary to assist with putting together a support team. And in those cases, we suggest that the individuals call upon one of our organizations, one of us who are on this call today, or that they look to other organizations in their community, such as the Centers for Independent Living, or Diversibility Incorporated, which is a statewide organization, Arizona's statewide independent living council, organizations such as that. But if no one else is available, contact one of our organizations and we can help provide some guidance. We can help either assist with putting together a support team and identifying appropriate members, or putting you in contact with organizations in your local community who can provide a similar service. Any other questions? Okay, not seeing any. It's now my privilege to turn the microphone over to our next presenter, who I believe is George Garcia.
Thank you. Okay, now we're going to be talking about choosing the right support person. Supporters should be someone you trust, or someone that the person with the disability who is using supported decision making as it should be someone they can trust. Now, trust is important because those supporters may be asked to assist in areas that are very personal to that person. For instance, if the person with the disability needs help in making medical decisions, supporter may be asked to attend medical appointments and hear some personal medical information that that person with the disability would like to keep private. Same thing whether they're being asked to do stuff in the area of finance and they may have to see their financial information. So the person with the disability should feel safe knowing that they can trust their supporter with that very personal information. Supporters should have knowledge in the areas in which they are being asked to provide support. Now, for instance, if someone is asked to assist a person in financial matters, you don't need to be a CPA or a financial advisor to provide that assistance, but you should have some basic knowledge in, for instance, going to the bank, working with bank tellers, creating basic budgets, areas in which that person with a disability may need some assistance. Supporters should not be biased. Supporters should not provide advice or support based on how it will benefit the supporter. The information that they provide should be clear and accurate so that the person with a disability can make the best decision for themselves without, having information that is skewed in one way or another. Under supported decision making, you can have more than one supporter. Supported decision making agreements can be with one person on one issue or one area, or it could be in multiple areas with multiple supporters. Now, it's okay to have a supported decision making agreement with one supporter, but it is actually best and safer when you have more than one supporter. Having more than one supporter prevents people from feeling overwhelmed. If there's only one supporter providing all the support, they might start to feel overwhelmed that they are providing too much assistance. But if you have multiple supporters, you can help lighten the load, so to speak. Another thing that, or another benefit of having multiple supporters is that you actually prevent abuse and fraud. Because the more people that are watching out and assisting the person with the disability, the more likely you are to catch any abuse or fraud from happening. Supported decision-making agreements are revocable. And we'll talk about this a little bit more in further down in the presentation, but supported decision-makings are revocable because they're not filed with the courts. You don't need to go to a judge, and it doesn't have to be agreed upon by any legal entity. And so if the person with the disability doesn't feel comfortable with the supporter or feels that they need to change who provides that support, it's perfectly fine to change that supported decision-making agreement or end it, and vice versa. If the supporter doesn't feel like they can provide the support that they have been asked to provide, they can change it or end it. Now, identifying possible supporters can be difficult, but a good way of keeping track of possible supporters is to create a chart. And in that chart, you can put possible supporters and in what areas you would like them to provide that support and how you would like their help. Here on the screen, we have an example. We have 3 columns. And as you can see on the left-hand column, we have possible supporters such as Charlie Patton. And in the areas of support, they would like Charlie to provide help in financial areas. And what kind of support would that person want? They would want assist with paying bills, assist with going to the bank, and assist with paying rent on time. So as you can see, the person with a disability and their families or caregivers or anybody else helping them create their supported decision-making agreements can put down what areas of support they would want so that they can find the right support person. And with that, I open it up to any questions. Not seeing none. So now we're going to be talking about asking someone to be your supporter. Asking someone to be your supporter can be one of the most important conversations that the person with the disability and their possible supporter will have. In fact, it may take more than one conversation before agreeing to work with each other. So it's important to be upfront about what is expected from each other. Next. Supported decision making can be a new idea for the supporter. In fact, a lot of people are still not very aware of what is supported decision making. So it's important to explain what is supported decision making. More importantly, it's important to explain the differences between supported decision making and guardianship. Remember, under supported decision making, the person with the disability makes their choices, makes all their choices. If that possible supporter cannot agree with that or doesn't believe that people with disabilities can make decisions for themselves, or that person with the disability can't make decisions for themselves, then it's not going to be a good fit. You probably should look for another supporter. Be clear and direct about the type of assistance that's going to be needed. How is that person going to provide that support? In what areas are they going to provide this support? And how does that person with the disability like to be supported? Things may change over time as they work together, but it's important to be clear and upfront in the beginning. And as things change, as the person with the disability becomes more independent on their own or may need more support, then that supported decision making role can change over time. It's important to be clear about what the role of the person with the disability is in a supported decision making agreement. People with disabilities take responsibility of their own lives. They make the decisions in supported decision making agreements. Supporters are only there to provide assistance. And with that, I open it up for any questions. So the question that I have is, what is the legal status of supported decision making in Arizona? So right now, anybody can use supported decision making. It's not something that requires a judge or a court to approve of. We have been trying to get it passed through the legislation to get it recognized under Arizona state statutes, but unfortunately this year it did not pass. And I can turn that over to John, as he's going to be the next presenter, and maybe you can talk a little bit more about that, John.
Thank you, George. I'd be happy to do that. With regard to the legislation that we introduced, there's a little bit of a history to it. We introduced legislation in the 2020 legislative session. It was quite successful. It passed the House of Representatives 59-1 and was transmitted to the Senate. But because of the pandemic, it was not able to receive a hearing in the Senate, and so the bill effectively died in 2020. We reintroduced the bill this year. It passed the House of Representatives 59-0 and passed the Judiciary Committee in the Senate as well, but failed by one vote on the floor of the Senate. So it did not make it to the governor's desk. That being said, we recognize a number of areas in which we need to make some improvements and do some additional communication, and we do intend to reintroduce legislation in 2022 regarding supported decision making. But as George said, it's not required that there be a law in place in order for individuals to use supported decision making. The intent of the legislation that we introduced was to provide some additional protections and some additional parameters really around the role of an individual acting as a supporter and the expectations that an individual with a disability can have for his or her supporters. Those legal protections, while we consider them to be very valuable, are not absolutely essential to an individual's using supported decision making. The story that I told you before about Tucker Merle and his family. The Merle family live here in Arizona. Jana, Tucker's mom, works for Raising Special Kids, which you've probably heard of. They are utilizing supported decision making in Tucker's life without the benefit of legislation in place. And there's nothing that prevents them from doing that. There's nothing that prevents anyone from doing that if they wish to. So that essentially is the legal status of it right now. And as I said, we intend to be reintroducing our legislation in 2022 and looking for the ways that will be necessary to get that legislation passed. Now I'm going to move on and talk a little bit more about supported decision-making agreements. George gave you a really good overview of what these agreements are all about and why they're important. And I would just emphasize that once a person with a disability is ready to choose a supporter or a group of supporters, they should create and sign supported decision-making agreements for each of those individuals acting as a supporter. I mentioned earlier that a supported decision-making agreement is a formal arrangement between supporter and the person with a disability. It's an agreement that turns informal supports, such as the kind of informal supports that many of us rely upon when we ask for a recommendation about a movie or a restaurant, into formal supports that describe the responsibilities of the supporter and the expectations of the person with the disability. By signing this agreement, supporters are agreeing to take on the responsibility of helping the person with the disability in those areas of life that are written into the agreement. These agreements also help to define the role of the supporter and the person with the disability because they explain what the supporter has the right to see or do within the agreement, such as the right to view certain documents or the right to provide advice on financial matters. And a signed agreement also demonstrates to other people who are important in the life of a person with a disability, such as doctors and lawyers and teachers, that a supporter has the approval of the person to assist with important decision making. Now, to be clear, and we've said this before, these agreements are not legally binding. They are not contracts. Supporters and people with disabilities who sign these agreements are not legally required to follow them, although there certainly are laws that apply to such things as neglect or exploitation. You can't defy those laws. But these agreements are not laws unto themselves, and they are not contracts. Furthermore, both the supporter and the person with the disability have the right to end the agreement at any time, as George mentioned. Even though a supported decision-making agreement currently has no legal enforcement, people should still take the time to create them, because supported decision-making agreements put into writing the expectations that individuals with disabilities and their supporters have for one another. They protect the privacy of a person with a disability because they do specify how much personal information a supporter has access to, and they can be provided to medical and social service providers to notify them of the role of the supporter. We found during our research as part of this pilot project that some medical providers, social services providers, some lawyers and bankers, for example, may not feel comfortable providing services to a person with a disability if they don't believe that person is able to understand the services or the information that they're receiving. But with a supporter assisting the person with a disability, service providers can feel entirely comfortable working with that person, knowing that there are also others there to help interpret if necessary and to help provide clarifying information related to what is being shared with them. While a supported decision-making agreement creates a formal relationship between the supporter and the person with a disability, the agreement does not give the person acting as the supporter blanket authorization to review or receive personal records. Supporters will not have access to financial records or or medical records, HIPAA-protected information, or FERPA-protected education information unless the person with the disability wants that supporter to see that information and provides a written document, typically a release of information document, to permit that kind of access to the individual. So let's take a look at a sample supported decision-making agreement. And this agreement has 4 sections, and I will point out that as part of our legislation, we included a template of this agreement. It actually is part of the bill that we introduced, and this is common in the other states, the 10 other states and the District of Columbia where supported decision-making laws are currently in effect. All of them include some form of a template or sample language that should be used as a minimum in a supported decision-making agreement. In our case, this template has 4 sections: the appointment of a supporter, the effective date or dates of the agreement, the consent of the supporter, and then the signatures and notarization on behalf of the individual with the disability. I'll explain a little bit more about each of these sections as we go along. What you'll see here is very, very small print, but I'm going to go through section by section in a way that you can actually see it. What you can probably tell is that it's not necessarily a long document. It doesn't need to be overly involved. It doesn't need lawyers involved in crafting it. It's a pretty simple and straightforward document. But bear in mind that not every supported decision-making agreement is going to look the same. This template provides basic information that you should find in every agreement, but all of them are going to be customized because a typical support team will be made up of multiple individuals, each of whom will play a different role, maybe only a slightly different role, but a different role in the life of the person with the disability. You can see that it contains a large number of blank lines for information that the person with the disability and the supporter need to fill in with important information. It also includes various areas in which the person with the disability needs to indicate what type of assistance the supporter is being asked to provide and how much personal information that supporter is allowed to see. So the first section of the agreement deals with the appointment or selection of a supporter. The person with the disability starts by placing his or her name in the first space to verify that this agreement is being made voluntarily. And in this area, the person with the disability also lists the name, address, other contact information for the individual supporter. Remember, each one of these agreements is going to be individualized to the particular supporter. So there will be multiple agreements in place for a particular support team. This is also the place where the person with a disability indicates what types of assistance he or she is asking this supporter to provide. Now, we've thrown in some more sample language, but this is the first area in which the information being asked for can really be customized. We've thrown in obtaining food, clothing, and shelter, taking care of my physical health, or managing my financial affairs. Now, that can be changed to suit the particular needs of the individual with the disability and the particular skills or attributes of the person acting as a supporter. The section goes on to explain how a supporter assists in the decision-making process and what actions they're being asked to take to provide guidance and help the person with the disability, and that they're not making decisions for the person with the disability, that they are providing guidance but not making decisions on behalf of that individual. You can see there are additional areas here where it specifies what that individual or supporter is being asked to provide. This is another area in which customization can certainly be done. Finally, there are the sections related to protected information, such as HIPAA-protected information or FERPA-protected education information. Yet again, this can be customized. If you want the person to be allowed to receive financial documentation or legal documentation or anything else that might be privileged and confidential, this would be an area to specify that. In the next section, the person with a disability states how long the agreement with this particular supporter is going to last, the effective dates of the agreement. Now, you can choose any period of time you want, or you can choose no period of time. It can be left open-ended. There's no requirement that it be for a specific period of time. It's entirely up to the individuals involved. You can make it last indefinitely if that's your choice. That is until whatever point someone decides to choose it or end it. The third section of the agreement requires that the supporter certify he or she is agreeing to be a supporter according to the requirements of the agreement, according to all of those things that are outlined previously, and then that the person is doing it voluntarily. That individual supporter then has to sign and date this section. And in the fourth and final section of the agreement, the person with the disability and two witnesses sign the document in the presence of a notary public. The notary public, if you're not familiar, is a person who has a special license from the county or the state to certify official documents. Once that agreement is signed by the person with the disability, by the witnesses, the notary will sign it, date it, stamp it with a special notary stamp, and that's it. The agreement becomes official. Now, again, although this may seem like a lot of work just to get somebody to voluntarily help you, we really believe that supported decision-making agreements are a very, very important component of the relationship and of the structure. For one thing, they let everyone who's involved with this know what's expected. For another thing, they provide protections for the person with the disability and the people who are serving as supporters. They're very, very helpful in letting healthcare providers and other professionals know that people stand beside you if you're a person with a disability to help you make challenging decisions. And as George pointed out, you aren't stuck in an agreement that doesn't work out. You can change it or end it at any time. So it's in everyone's best interest to make sure a good supported decision-making agreement is in place. And I would be happy to answer any questions related to supported decision-making agreements. Hannah is asking, if someone is using supported decision-making, will that help them advocate against a guardianship proceeding? Is it recognized by the courts? Officially, and I'm going to answer part of it and then I'll turn it over to Cy because I think he can answer it a little bit more. Officially, they are not recognized by the courts because they are not legal contracts and not protected by law. Will it help them advocate against a guardianship agreement? It certainly could, if it can demonstrate, if a supported decision-making arrangement that's in place can act as a demonstration that the person has decision-making capacity and has been successful at making life decisions using the support that's provided by that support team. It should operate, and of course, any court or any judge will make his or her own decision, but it should act as evidence that the individual has that decision-making capacity and utilizes it well. So I would ask Cy if he's got anything more to add to that.
Hi. So just two things to add. So one, like John said, it can be used as evidence. So like I was saying before, the person who is subject to guardianship has due process protections, and they are allowed to put forth their evidence to show that they do have capacity. So one way of doing that is to show evidence of a successful supported agreement arrangement, and that they've been able to utilize their supports in a way that that helps them live and do things without great risk to them. The second thing is the Arizona revised statutes or Arizona law says that judges must make findings that other least restrictive alternatives aren't available. So other least restrictive alternatives could be supported decision making, or it could be limited guardianship. Although like John said, there has been no case law that discusses supported decision making in Arizona. There has been in other jurisdictions like New York, but no supported decision making cases in Arizona yet. So this could be an interesting development. So supported decision making is still pretty new. It's like new-ish. It's been around for a couple of years, and like John said, it's fast. It's available in a number of jurisdictions. So there could be future challenges involving supported decision making in the future.
Okay, thank you, Sai. And Ellen is asking, where do we find the template for this document? That document can be found on the Southwest Institute for Families and Children website at swifamilies.org under the Supported Decision Making tab, or you can email any one of us. Our contact information will be provided at the end of the presentation, and any of us can send you a copy of that template. Okay, so we've got another poll question for you. Given that you've been on the phone with us for a little over an hour now, we've provided you with a wealth of information. If you had the right type of help, is supported decision making something that you would try, either as a person with a disability or if you are a caregiver for someone with a disability? Is supported decision making something you think you would like to try? 1, yes. 2, no. 3, I need to think about it more. Or 4, I need more information before making that decision. All right, we've got 4 ones, and we've got an I need to think about it. Perfectly legitimate. Perfectly legitimate. Another I need to think about it. Okay, well, if you do need to think about it more, or even if you think you've already made a decision that it is something you'd like to try, always feel free to contact us. We are more than happy to provide whatever information you need to help you understand this better, to answer whatever questions you have. So do not hesitate to contact us. As I said, our information will be provided at the end of the presentation. We would love to share more information. We would love to help you get whatever you need so that you're comfortable with the notion of supported decision making. And thank you very much for participating in the poll. I am now going to turn it over to our next presenter.
Hello, everybody, and I'm going to be talking about self-advocacy and supported decision-making. What is self-advocacy? Self-advocacy is the ability to speak up for oneself and communicate wants and needs. Self-advocates are people with disabilities. They are the decision makers of their lives and should have that opportunity to do so. It is important to encourage the person to use and to develop self-advocacy skills throughout a person's life. Do not make decisions for the person with a disability. The most important thing is to let them make their own decisions. The purpose of supported decision making is to maintain independence. Unless a supporter is given certain rights, supporters are there to help the person understand their choices. As is life, things may not always go well, but failure should not be a reason to take away a person's rights. Encourage the person with a disability to ask questions. And here's where people with disabilities may need their community to help them out. Supporters can help out by encouraging people to ask questions about decisions that will affect their life choices and lifestyles. The person with a disability may not always be familiar with the topics or issues they have to deal with in their lives. Supporters can have a discussion about the pros and cons about possible options. Anyone can have a hard time deciding what is best for them. This can be overwhelming and discouraging, especially for a person with a disability. A supporter can encourage the person to ask questions until they feel comfortable making those decisions. And explain things in easy to understand manner. There are many ways to support a person with a disability. Some examples include use plain language. This means that the information is at a grade level of about 4th grade, where people can understand the information in simple terms. Avoid using large words. But however, sometimes you need to use the words that are part of programs and government systems and agencies that use them. But it can be described for people with disabilities to understand, define technical terms, and explain what they mean. Finally, break down information and tasks in each easy to understand steps. Sometimes taking time to understand the process may take a person with a disability time to digest what it is all about. And with that, I'm going to open it up for any questions on that section. I don't think we have any questions, so I'm going to go ahead and pass it on to Sai to finish us off.
Hi, everyone. So I am going to continue the conversation and to talk about alternatives and complements to supported decision making, or alternatives and complements. So, like I said before, like if there are only certain areas of an individual's life where the individual needs assistance, then oh, I've advanced too much. Okay, yeah. If so, for example, if the individual just needs help with finances, then instead of pursuing a full supported, instead of pursuing a full guardianship, it could behoove the family and the individual with the disability to consider other alternatives like financial alternatives or things like that. So in this section, I'm going to talk about alternatives and complements. So the first alternative could be the representative payee program. So for those of you who might not know, the representative payee program is a program run by Social Security, and it provides benefit management for beneficiaries who are incapable of managing their Social Security or supplemental security income. So this could be a great option for those who can live in the community independently, but might have difficulty managing their monthly expenses. So in this case, Social Security will appoint a suitable rep payee who will manage the beneficiary's benefits. So Social Security will choose family members or friends, and if not, organizations can serve as a rep payee. Most rep payees will have to fill out an annual accounting. So as these are forms, Social Security will use to ensure that the individual's current needs are being met. All payees are responsible for accurate record keeping. The payee receives payments for the individual and must use the money to pay for the individual's current needs. After the payee pays for those expenses, they can use the rest of the money for any other things like past due items, or providing entertainment, or saving the money for future use, but keeping in mind income resource limits. So Social Security will carefully or works carefully to ensure that the benefits are being used appropriately and to the benefits and that it benefits the recipient. So Social Security may schedule an interview with rep payees and beneficiaries to conduct additional reviews. So advanced directives and living wills, these two are instruments that are used for future healthcare decisions. These are instructions for someone the individual chooses if they are unable to communicate and make healthcare decisions. And these can be really helpful for individuals with age-related disabilities who might or who have capacity at the outset, but might be experiencing age-related disabilities later on. So advanced directives are where an individual can appoint an agent to make future healthcare decisions if the individual becomes too ill or cannot make the decisions on their own behalf. The individual, of course, should appoint someone they trust, like a parent, a sibling, or a trusted family member. And the individual should discuss these healthcare decisions, these things with their with their doctor to make sure that they have a thorough understanding of what all is involved. Living wills, on the other hand, is a document that provides instructions relating to future healthcare decisions. So the individual can authorize specific healthcare decisions on the outset, and those healthcare decisions will have to be respected by whoever is appointed to execute the living will. So examples can include consenting or refusing certain medical procedures, approving or denying admittance to like nursing homes or assisted living centers, being placed on a ventilator, and things like that. Conservatorship is a guardianship of the estate. So where guardianship is guardian of the individual, conservatorship is guardian of the estate. And a conservator is an individual or corporation appointed by the court to manage another individual's financial affairs. To be appointed, the court will determine whether the individual has sufficient understanding or capacity to make or communicate responsible financial decisions. So again, with similar to guardianship, there are individuals who are generally preferred to serve as a conservator, and again, the individual who is subject to a conservatorship does have similar due process protections as they would under guardianship. A durable power of attorney is a legal document where the principal, the individual, gives another person, the agent in this case, permission to act on their behalf in financial matters. So the agent can make legal decisions that would bind the principal, and the principal should choose someone they trust, of course, because this individual is essentially making financial decisions on their behalf. So some examples of things an individual can give their power of attorney can include signing contracts, making financial decisions, purchasing a car. Authorized representative in vocational rehabilitation is for individuals who might need employment assistance. So Voc Rehab is an agency, a state agency, that is designed to help an individual attain and retain employment services. So the Voc Rehab client can choose someone they trust, like a parent, a friend, or an advocate, and that individual, that authorized representative, can assist the individual in advocating for their rights in the application process, implementation of the IPE, and during any appeal process if there are adverse decisions that had been made. So all of those things that I just talked about is available in our legal options manual, and the link is right there if anyone wants to peruse it. And all the information that I spoke about is about Social Security is right there too. So Hannah asks, is anyone offering training to self-advocates on how to move forward in supported decision making? So that is a fantastic question. So George and John can probably speak to this more, but so the partners in this case are looking forward to creating clinic programs to help individuals find supporters, implement supported decision makings, and take next steps. So this is all in the planning stages right now. So we don't have anything too concrete right now, but there are resources available at the Southwest Institute for Families website if individuals want to get a head start and review those materials to to implement these agreements. And I am going to pause for some more Q&As, and so this will be the last Q&A. So if you have any questions that you've been holding on to, feel free to ask them now. Otherwise, if you have a question later on, like in the day or the week, feel free to email one of us, and we're gonna put our email address on one of these screens. So actually, I'm going to pass it over back to George Garcia for some closing remarks, and he's going to share our email addresses.
All right, thank you, Zai. So that concludes our training for today, but there is still lots of information that you can find by visiting our website at swifamilies.org and clicking on the Supported Decision-Making Pilot Project tab. There you can download the training manual, which will include all the templates for any of the worksheets that we've created, as well as a template for the supported decision-making agreement. There's also videos there on each one of the different segments of the training manual, where if you don't want to read the manual and you would just like to see a video presentation, you can click on each one of the individual YouTube videos. And any of the videos that include worksheets will have a link where you can download the PDF copy of that worksheet. You can find us on Facebook for any upcoming news and trainings or any events regarding supported decision making. And you can find us on Facebook by searching Arizona SDM. So you can see up in the corner, we also have a little QR code there. Just take a picture of that with your cell phone, and it'll give you a link to our website. Next. Contact information. You can, if you look on your screen right now, we have all three of our organizations where you can contact us if you have any questions or concerns or would like more information. And with that, thank you guys so much for participating. And if you need anything from us, just feel free to let us know.